If you want to hire an attorney, this is what it looks like going in the door. You call the law firm, and I'm gonna get very granular with you. You call the law firm, and you're going to talk to either the receptionist or one of their paralegals or intake clerks, and you're going to say, "Hey, I want to come in for a consultation. Refer to you, whatever the case might be." And the first thing they're going to do is check a conflict check, which means they're going to log in and see in their files if your spouse has previously consulted with them, because if they have, they cannot consult with you. And what we were told to say a long time ago by a law firm is just say, "Sorry, we're unable to assist you," and give no explanation, not even to tell them, "Hey, your spouse already consulted." And I guess that makes sense, right? Because if this person's calling to get a consultation, we're like, "Oh, your spouse already called us." We don't want to be that middleman. It's not a problem now. Back then, they didn't want to get involved in that, so they say, "Sorry, we can't assist you," and just hang up and give no explanation. So first, they do a conflict check. Then, if no conflict, they'll schedule a consultation. After quoting you a fee, they'll take some notes down about your case, what's going on, is there open case, et cetera, how long you've been married, is there kids, what's happening, and then schedule in for a consultation. You'll come in, you'll have your consultation with your attorney, and after the consultation, they will go over they'll talk about the cost, they'll have a retainer agreement for you, the hourly fees of the attorneys and paralegals, all that. And that process, so that intake is completely different than mine, which I'll get into that later. Then, the first step is filing for divorce. That's the same here. Then the next step is to, file it, serve your spouse. So probably get a process server and do it in a fashion that will stir the pot, having them personally served at home or work by a process server or the sheriff. And that's going to kick things off in a pretty negative way, even if you guys were somewhat amicable. Then what's next? Your spouse is going to get served, and they have 30 days to do their response. In those cases, you have to respond. Your wife or your spouse has an attorney. And so now you're probably going to need an attorney, and you need to go have a consultation. And then that person is going to file a response. We don't file responses in our cases because it's amicable. And I'll get into that. Then the next step is within 60 days, your attorney is probably going to have a communication with your spouse's attorney in saying, "Hey, and if they're local, if they're all local, they'll probably just have a conversation and see what's what." The next step is to do the disclosures, and they will do the formal preliminary declaration of disclosures and serve those on your spouse, and the other party will do the same. Until that happens, there's usually no discussion of a settlement or terms or anything like that. Now, some attorneys, if there's some, for a variety of reasons, they will also propound discovery. And this is like going deeper into your finances other than just the preliminary declaration disclosure, where you're basically giving kind of your most recent statements, bank accounts, pensions, income and expense, 2 years tax return, et cetera. This is discovery to say, we want to go deeper. We want to go 5 years deep, 8 years deep. Maybe the marriage was 10 years, so they want to go 10 years deep. That can be very, very costly. So this is the information that this client that hired me was talking about. And I said, "Look, our service is completely different than that." And again, I'll get into that in a second. So discovery is possibly done. If there's an agreement at that point, there'll be maybe 4-way settlement agreements, and then that could finalize that way. Otherwise, no agreement, you're going to court. Someone's going to have to file a request for order. You're going to have to prepare that. That's it's going to cost you another $2,500 plus fees to go to court. You're going to have a hearing. That's going to be more hourly fees. And that's for both of you, you and your spouse. They're going to go and argue the points for whatever you guys don't agree on: spouse support, child support, custody, whatever. You'll come out of that hearing with orders from the judge. But guess what? Your divorce still isn't done. That is just a hearing on whatever issue is brought up, like in the case I spoke about earlier, where they were just addressing spouse support. You still need to finalize your divorce on everything else. So let's assume that whatever issues you guys had were resolved and everything else you guys are able to figure out. Then your attorneys can draft the settlement agreement, incorporate the order from the court, from whatever issue you had of that request for order, and then you guys can finalize. That's why this can take 6 months, a year and a half, or longer, depending on how litigated your case